This video is part of a series intended to help citizens, members of the media, public officials, or anyone acting on their behalf to better understand Florida's exceedingly broad Public Records Act. These videos may be used by anyone and may be freely distributed without charge. I am not an attorney. I am not qualified, nor am I authorized to give legal advice to the public, so I don't. Any information provided by me in person, on video, or through fogwatch.org is readily available from the Florida First Amendment Foundation and the Florida Attorney General's Office of Open Government, as well as many other sources online. It is well established within Florida's legal tradition that citizens have a right to know what their government is doing in their name and at their expense. For more than 100 years, the right to know has been repeatedly and vigorously validated by the legislature, the voters, and the courts of this state. The legislature of Florida has expressed its intention that the citizens of this state shall enjoy the right to inspect and copy records. In 1892, the Florida legislature passed this state's first public records law, which required that records created and maintained by public officials shall always be open to the public for the purpose of inspection thereof and of making extractions therefrom. In 1909, the Florida legislature further solidified the public's right to know when it adopted Chapter 5949 of the Florida Statutes, which required that all state, county, and municipal records shall at all times be open for personal inspection by any citizen of Florida, and those in charge shall not refuse this privilege. In 1967, the Florida legislature created the Public Records Act with the passage of Chapter 119 of the Florida Statutes. For the first time, the legislators of this state expansively defined a public record as any document, paper, letter, map, book, tape, photograph, film, sound recording, or other material, regardless of physical form or characteristic, made or received in connection with the official business of any agency. The Public Records Act also defined an agency as any state, county, or municipal officer, department, division, board, bureau, commission, or other separate unit of government created or established by law. In 1975, the Florida legislature expanded the public's right to know by expressly placing the power to create exemptions to public records access exclusively in the hands of the legislature. The legislative changes also eliminated the citizenship requirement and made public records access a right to be enjoyed by any person. The legislation also broadened the definition of an agency to include districts, authorities, and any other public or private agency, person, partnership, corporation, or business activity acting on behalf of any public agency. Finally, the legislative changes in 1975 created a provision for an expedited court hearing when legal action is taken to vindicate the public's right to know.